Indian Dispute Resolution Centre in collaboration with the Bar Council of India's IIULER successfully hosted the third Arbitrate in India Conclave 2024 on 29 November 2024 at the India International Centre, Lodhi Estate, New Delhi.
May I request the esteemed panelists to please grace the stage. I'm pleased to introduce to our esteemed panelists for the evening. I would like to request Honorable Ms. Justice Hima Kohli Madam, former Judge, Supreme Court of India, to please grace the dais as the chair of the panel. I invite our esteemed panelist, Mr. R. Venkatramani, Sir, Attorney General of India, as the co-chair. As the co-chair of the panel, Sir, Senior Advocate, Supreme Court of India, Mr. Tejas Karya, Sir, Head Arbitration, Shardu Ramanchand, and Mr. R. Partner, Human Law Offices, and Ambassador India for the Vienna International Arbitration Centre to kindly grace the dais. With the due permission of our Honourable Chair and Co-Chair of today's first panel discussion, may we commence the conclave?
I think Manan sir is just on his way, so we'll just wait for him.
Now, I would like to introduce our esteemed panelists. Honorable Justice Ms. Hima Kohli Madam. Madam did her schooling from St. Thomas School, New Delhi, and graduated in History Honours from St. Stephen's College, University of Delhi. Her ladyship completed her post-graduation in History in First Division and thereafter pursued a law degree from Tax Law Centre. She enrolled in the Bar Council of Delhi in 1994 after completing her law degree. Madam served as the Standing Counsel and Legal Advisory of the New Delhi Municipal Council in the Municipal Council in the High Court of Delhi and was appointed as the Additional Standing Counsel for the Government of NCT of Delhi in the Delhi High Court. She has represented the Government of Delhi in several important public interest litigations. Madam was the legal advisor to the Public Grievances Commission, Delhi Pollution Control Committee, National Agricultural Cooperative Marketing Federation of India, National Cooperative Development Corporation, and other private organizations. Ladyship was appointed as an additional judge of the High Court of Delhi in 2006 and was appointed as a judge of the Supreme Court of India in 2021 and retired recently on 30th August 2024. Her ladyship has served as the chairperson and member of several government organizations and has played a significant role in their growth and development. Apart from performing her official duties as a judge, Madam takes a keen interest in promoting mediation as an alternative dispute resolution forum, in highlighting the role of the judiciary in preservation of the ecology and environment and the role of family courts in resolving family disputes. We thank you, ma'am, for sparing your precious time and joining us today. May I please request Ms. Ria to kindly welcome and felicitate her ladyship by presenting a memento and a delivery. Thank you, Ria. Next, we have with us Mr. R. Venkatramani, Sir, Attorney General of India and a senior advocate with an enriching experience spanning over 4 decades before the Honorable Supreme Court of India. Sir enrolled with the Bar Council of Tamil Nadu in 1977. He has been appearing for the state of Tamil Nadu as a special senior counsel and also acting as a special senior counsel for the state of Andhra Pradesh. Sir is also retained by the Tamil Nadu Electricity Board to represent its cases before the Supreme Court and the Electricity Appellate Tribunal, New Delhi. Sir has also been engaged by the Ministry of Finance, Ministry of Railways, and Ministry of Health and Welfare as a special counsel. Sir has also acted as standing counsel for various universities and public sector corporations, counsel for the Supreme Court in matters pertaining to the employees of the court, co-opted member of the expert group constituted by the Ministry of Minority Affairs to examine and determine the structure and functions of the Equal Opportunity Commission. Sir was invited to be a member of the Ethics Committee of the Indian Council for Medical Research, member cum office bearer of several lawyers' associations, life member of Indian Society of International Law, resource person of the Society for its annual summer courses, and actively participating in the projects of the Society, member Indian Law Institute. Thank you, sir, for joining us today and being a part of this esteemed panel. We thank you for your time. May I please request Mr. Ndian to kindly welcome and felicitate sir. Now, moving on to the next panelist, we have with us Mr. Ratan K. Singh, sir, Senior Advocate and International Member, Keating Chambers. Sir is one of the leading arbitrators and counsels who specializes in complex, high-value construction, engineering, infrastructure, mining, and commercial arbitration in India, as well as internationally. He is also an international member of Keating Chambers in London. From serving as the chair of tribunals to representing parties, he has a broad experience in international arbitration under the rules of ICC, UNCITRAL, SIAC, LCIA, DIAC, and many others. He is also the founder chairman of the Society of Construction Law India and director of the Chartered Institute of Arbitrators India branch. Sir has received several fellowships from numerous internationally reputed organizations. In fact, Sir is the only Indian to receive a fellowship from the International Construction Law Association. May I please sorry. May I please request Bhavika to please kindly felicitate sir. Thank you, Bhavika. Next, we have with us Mr. Tejas Karya, sir. Tejas, sir, is a partner at Chardol Amarchand Mangaldas, one of the leading law firms in India, and also heads the arbitration practice of the firm. Sir has an extensive experience handling a broad range of complex, high-value international and domestic commercial disputes and frequently advises clients across diverse industry sectors. He has also contributed to policy formulation in the domain of arbitration. He has advised on the drafting of amendments to the Arbitration and Conciliation Act 1996 and the Commercial Courts Act, Commercial Division and Commercial Appellate Division of High Courts Bill 2015. He has also been a part of the high-powered committee set up by the Government of India for institutionalization of arbitration in India. Thank you for joining us today, sir, and making time for this event from your busy schedule. May I please request Ms. Janvi to kindly felicitate, sir. Thank you, Janvi. Next, we have with us, moving on to our youngest panelist and the moderator for the panel, Mr. Arif Khanna, sir. Arif, sir, is an advocate and legal consultant enrolled with the Bar Council of Delhi. He started his practice in 2012 after graduating from the Symbiosis Law School, Pune, and has also completed his master's from the National Law School of India, University, Bangalore. He specializes in commercial disputes with a key focus on arbitration, IBC, and antitrust. The list of clients he currently represents and advises includes Fortune 100 companies such as the Lenovo Group and Motorola Inc., and other multinational companies such as Corning and TGI Fridays. In addition to his commercial assignments, he also acts as a counsel for charitable institutions such as the Missionaries of Charity, Indian Cancer Society, and is also on panel with the Delhi High Court Legal Aid Committee. Arif sir is also Ambassador India for the Vienna International Arbitration, sir. We thank you for joining us today, sir. May I please request may I please request Yashma to kindly felicitate, sir.
Thank you very much.
Thank you, Yashwin. Now I'd like to request Arush sir to please proceed with the panel discussion.
Well, warm greetings of the day to everyone in the audience. It is indeed endearing to see a packed auditorium on a Friday evening at this wonderfully curated third Arbitrate India Conclave 2024 organized by the IDRC. At the outset, I wish to express my heartfelt gratitude to the organizers for considering me worthy of such a unique opportunity to share the dais with such eminent stalwarts, all of whom have been tremendous sources of inspiration for an entire generation of aspiring court and arbitration practitioners, including myself. So, the topic or a part thereof of today's panel is India as a hub for institutional arbitration. During the panel, our expert speakers would share their insights on the evolving landscape of the Indian arbitration regime, a concerted stakeholder movement towards making India an institutional arbitration hub and making institutional arbitration the norm rather than the exception. And we'll also talk about the role of courts as well as the bar, including the Arbitration Bar of India. Our experts will also be sharing their views on the recently circulated draft amendments to the Arbitration Act, including certain recommendations aimed at streamlining ad hoc arbitration. Speaking of ad hoc arbitration, a part of our topic today also includes a debate on institutional versus ad hoc arbitration. I'm particularly intrigued with the use of the word or the term versus. Are institutional and ad hoc arbitrations actually adversaries? In a massive economic landscape like India, do we need to do away with one to encourage the other? What may be too informal for an organized economy may be too prescriptive and costly for the informal economy, including our MSMEs. So, on that curious note, I would like to ask my first question to the Honorable Chair. Ma'am, firstly, it's an honor to have you here, and it's an honor for me to share the dais with you. At a recent conference, you had advocated for minimum judicial interference in arbitration, restricted to only exceptional circumstances. You also alluded to the fact that in a modern progressive arbitration regime, both courts and tribunals ought to have clear demarcated responsibilities. Keeping with that chain of thought, what are your views on the prospect of having an appellate arbitral tribunal hearing challenges to awards using the same yardstick as courts? For example, public policy. Do you feel broader issues like policy of Indian law should be confined to our state courts instead of contractually agreed appellate tribunals? We can't, once you go to the court of your seat, you can't choose a judge, but you can still choose an arbitrator. Choice is often a privilege, but at times can be a problem. So, will this reduce court interference in the long run? So, ma'am, over to you. Thank you.
So there are multiple questions that have been thrown at me, as you can make out. And to start with, a very good evening. It's a pleasure to see so many of you here, and many of us who are serious practitioners. And happy to note that you've decided to spare your time and be part of this IDRC conclave. I hope that we will all pick up something from each other and go richer by the end of the day. So coming to this question that Arush has thrown, or should I say questions in plural. Yes, recently when I had gone to Dubai to attend the Dubai Arbitration Week 24 in November, I did say that minimum judicial interference in arbitration should be the focus of the court, and that it should be limited to exceptional circumstances for obvious reasons. The whole purpose of having this enactment in place was to ensure that if parties have agreed to a particular forum for dispute adjudication, then courts should be the last body to interfere, whether it was at the stage of appointment of arbitrators or in the course of the arbitration proceedings, or even when the award comes, unless and until those minimum parameters that are, and now they have been pared down, as we all know, over a period of time, since 1996 to now, where judicial interference is required. So if it really goes to the root of the matter, if it is fundamentally against the public policy and so on and so forth, I don't need to expound on it. You all know that those are those 3-4 criterias and no more. And nothing on merit should engage an appellate court. And when we say appellate, at that, as it stands today, before the amendments come in, there's still work under progress. The appellate would mean a Section 34 or a Section 37. But if there is an appellate tribunal within the arbitration set up as proposed, well, then that will also be guided by the same parameters that have been laid down for courts to adhere to. Minimum interference, unless it goes to the root of the problem, or it is a fundamental issue, or it's against public policy. Those are the kind of things that one would have to look at for an arbitral tribunal, which is an appellate tribunal, and confine itself to within those parameters, how much interference is required. So again, no interference on merits. If there is one view that is possible, then adhere to the view. Simply because the tribunal thinks the appellate tribunal another view is possible, it will not interfere, just as a court does in 34. And higher we go in the pyramid, the more narrow the scope of interference. That is the primary thing that is important. Coming to another question that Arush has asked us, do you feel broader issues such as public policy should be confined to state courts? Well, public policy's interpretation is different in each country. It can't be the same for one country and another. So when he's saying public policy to state courts, obviously he is talking of domestic arbitrations. But there can be instances in international arbitration too, when it goes completely against public policy, a particular nuanced award, then perhaps that window will have to be kept open for the courts to examine. I'm not saying interfere, I'm saying examine. And courts are careful in interfering in any international arbitration award. We all know that, unless it is imperative. It's normally a case of implementation of the award, where a party approaches the court after an award is made. So I think that it will be a very conservative approach that the courts have adopted, and a similar procedure, if implemented and legislated as proposed in the draft, would have to be adopted by the appellate tribunal within the arbitration regime, if there is such a tier opted for by the parties. Let's put it like that.
Thank you, ma'am, for your most valuable insight. I think the broader object and purport of what you're saying is essentially that clarity in circumstances wherein judicial interference, or perhaps prospectively interference by the appellate tribunal is warranted, has to be clear. I think clarity of circumstances is essential for harboring any aspirations to becoming a hub for international arbitration. I mean, we all know of the recent ruling that happened in the DMRC case, wherein an award was interfered with at a curative stage. Now, whether that is right or wrong is a topic for perhaps another day. But I think clarity of the scope of interference is quintessential for us to be a hub. Now I have the honor of addressing my first question to the Honorable Attorney General for India, who's also our co-chair for today's panel. Sir, apart from being the leader of our bar, you're also the patron-in-chief of the Arbitration Bar of India. And on behalf of the young arbitration practitioners community, I can say with some level of responsibility that the launch of the arbitration bar has evoked a great sense of excitement amongst all practitioners, students, scholars, etc. That said, sir, a few weeks into the launch of the ABI, we saw a circular issued by the MOF, which called upon PSUs and other government bodies to refrain from taking recourse to arbitration in procurement contracts. Following soon after, sir, they were the draft amendments, which have also, as we see them today, raised a few eyebrows on issues like the lack of clarity when it comes to arbitrability of fraud, the reintegration of patent illegality as a ground for interfering in award in international commercial arbitration. So do you think these moves stand to be obstacles in our march towards becoming a hub for international arbitration, or in your words, a global trendsetter in institutional arbitration? And my last question is, how does the Arbitration Bar of India plan to address these issues, if at all they are required to be addressed? Over to you, sir. Again, a couple of questions, not just one.
Let me start from the last question. It's better to start from the last. When the idea of an arbitration bar of India came into our mind, the question was, why do we have another bar? And if it's going to merely bring together practitioners in a certain field, then of course it could be a mere name and a mere grouping of people. But my idea was something beyond that. For long, we have been talking about ad hoc versus institutionalization of arbitration process in India. Our transition from the 1940 Act to the 1996 Act has been fairly slow and for good reasons, bad reasons. The culture of the 1940 Act somehow got into our psyche, even in the 1996 Act. So for a long time, we were not able to get liberated from some of those very embedded principles in the 1940 Act. Then we were confronted with the situation that both in government and private contracts, the process of choosing arbitrators was left to the great glorified party autonomy principle. That ran into some difficulties in recent times. That's a different issue. So, in that situation, one finds that ad hocism was a necessary byproduct of a lack of attention to certain important fundamentals. But I suppose ad hocism has also given us some lessons. We learn from that to find out how better and how good and how effectively we can bring about institutionalized arbitration process in India. Without lessons drawn from ad hocism, probably would not have been able to gather some rich insights into institutionalization process. And what kind of a trigger mechanism you would require to ensure we transition from ad hocism to institutionalization? So in that context, I thought that we can have a dedicated bar which will probably spread its ability to influence ideas, practices, and procedures in all areas of arbitration, so that we're able to slowly move away from ad hocism. I look at the Arbitration Bar of India as a tool, a very effective tool towards institutionalization, but there are other factors and players will do that. Government will have to do that, private entities will have to do that, but something which will facilitate and give a certain sense of strength and importance to the process, I thought, is an Arbitration Bar of India. Now, moving to other question. What has troubled me over a long period is the ethics part of it. And by now, universally, UNCITRAL or any other model have virtually laid down the foundations for the arbitration world. But even then, we have certain dragging questions. It is in those narrow areas of dragging questions where the ethical part of it comes in. We have examples like the MRC. So they don't really constitute the mainstream of the arbitral practice and intervention by superior courts. So having studied both as a practitioner of law, I would have been only probably practicing arbitration law. But having got into this position, one gets to know more closely what factors goes into constitution of a tribunal and what factors go into the conduct of proceeding before the tribunal, and many of those unfortunate things which can happen even in a government arbitration. So once you picked up those insights for what can make an arbitration process less holy, if we put it like that, then therefore we have to draw some lessons from that. So it is not therefore we can answer all questions about ethics in matters of procedures, or streamlining procedures. So it is not that we will be able to go on a framework and answer the ethical question. But then ethical question and connected with the institutionalization have a certain connection. So if you have better institutionalization and more an inbuilt accountability and party autonomy, so that you're able to answer ethical questions, I think the need for courts intervention to a large extent will be minimized. Our transition or movement from the patent illegality, I think that's not going to be a major issue. But you enter into the public policy question, as Himakoli rightly pointed out, we have different legal systems where perception on public policy may vary differently, to a large extent or in a subtle way. When it comes to that, I understand in some recent arbitrations where I was myself appearing, so I asked myself a question: should I not refuse to let my thought process and inquiry go too large and too wide? So that I refrain myself from asking only fundamental questions. So as a practitioners of law, many of us are tempted even today because we are answerable and accountable to our clients, right? And therefore, I'm trying to understand and grapple with this question. You will find large number of literature in about international arbitration and the ethics issue. On a slight note of digression, we also have a cultural question. One of the books on culture of international arbitration begins with a story about a case from Africa. So the three arbitral tribunal members, one drawn from Australia, one from Europe, another from USA. Now, the witness who was to give a statement is from Africa. Now, a question is put to him. Question is about a color of a certain product. So you have a difficult issues in language. So if in an African language, orange can means red, right? So it can make a world of difference in the way one understands the process of arbitration. Why I'm talking about it? The culture of arbitration in India. Yeah, I've been traveling recently in different parts of the world to look at how the arbitral practice in different parts of the world are functioning, taking stock of ethics and the culture. So it's in that context I thought an arbitral bar of India will make a world of difference. And I'm sure it's going to make a world of difference. So to answer finally, I don't think the circular issued by the government of India is going to be a big matter of challenge. And it is I think, a coincidence that the arbitration bar of India was born a little before after the circular was issued. Probably an unfortunate coincidence. But I've been talking to the government, and the misgivings within government about why they need to travel into the circular, I also understood there are good reasons. So, but ultimately it's all about the ethics of it. It's faintly reflected in the circular itself. But I suppose as soon as we are able to move into an institutionalization process, and we have many institutions, private and public institutions, IASC, etc., I suppose that they'll all be catalytic in institutionalization process. Over a period of time, the circular will probably die a natural death. I think it's better to allow it to die a natural death than to have an artificial engagement with that and to ask of it to die, right? I suppose we are confident as we grow into this that it will have a natural death.
Thank you so much, sir. I think your views are most reassuring and reaffirm the sense of excitement and anticipation that on the role of arbitration bar of India in really fueling India's growing aspirations of being an arbitration friendly seat. And sir, I think you rightly spoke about question of ethics and culture in arbitration. And ordinarily speaking, in law of averages, questionable ethics are normally more exposed or come to a forefront in ad hoc arbitrations. And speaking of ad hoc arbitrations, I will move on from one leader of the arbitration bar of India to another one. Mr. Karya, you have been one of India's leading soldiers in our march towards becoming a hub for international arbitration. Now, of course, we do have aspirations of institutionalizing the arbitration process and the entire regime in India. But numerically speaking, the ground reality is that ad hoc arbitrations still dominate the landscape. The draft amendments propose to actually institutionalize even the concept of an ad hoc arbitration. It actually empowers the council to frame model rules and guidelines for conduct of ad hoc arbitrations. Even the fees of the tribunal is now to be regulated by the council as opposed to Schedule 4 of the Act. Do you think this is a move in the right direction, sir? Or do you think it will increase surveillance, thereby curtailing the cardinal principle of party autonomy? So over to you, sir.
Yeah, thank you. As usual, you're asking multiple questions, so we'll answer that. But before that, good evening, everyone. It's my pleasure to be in the third consecutive Arbitrate in India conclave. I started with the first, second, and third, so I'm really grateful to IDRC for inviting me in all the three conclaves so far. And like previous edition, this time also we have the great speakers, and I'm lucky to have Ms. Justice Hima Kohli and also Attorney General for India and Mr. Ratan Singh, and of course our own Arush. Coming straight to the answer Arush has asked, this is the almost fourth round of amendments we are going to have in our Arbitration Act in last 1 decade, and we have come a long way in the journey of institutionalizing the arbitration in India. Traditionally, preference has always been to go for ad hoc arbitration, and we still continue to have many new contracts getting executed having ad hoc arbitrations. And the reasons are many-fold, and some of them is party autonomy, flexibility, less expensive. But I would say all this are arising out of lack of familiarity or the lack of experience of institutional arbitration by the users of the arbitration as well as the drafters of the arbitration clauses. And the way we have approached this issue is to introduce the institutional arbitration as an integral part of our legislation itself. And in 2015, when we first amended our statute since 1996, we have introduced series of amendments which are promoting the institutional arbitrations. 2019 again was the second series of amendments where we introduced institutional arbitration, but it is a work in progress. We need to achieve the institutionalization over a period of time, but at the same time, we need to also address the ad hoc arbitration, and the best way is to address ad hoc arbitration is to address the two aspects. One is the time, the other is the cost. And what the circular also which we see is as Learned Attorney General for India has said, they have genuine concerns, and we as an arbitration community cannot turn a blind eye about this serious concerns may it be coming from the government or the private sector. We need to address them straight and with the effective measures. And Arbitration Bar of India is one of the answers. The other answer is also to further amend the law to streamline the process, standardize the process of arbitration, and bring the certainty in terms of the time and the cost for arbitration. So I was part of just Mr. Vishwanathan committee, and we discussed and deliberated these issues. And one of them is to bring about a model rules for the ad hoc arbitration, so which is very similar to time-tested rules of all the arbitral institutions. The biggest advantage of institutional arbitration is that we have a set of rules which are applied to the arbitration process, which brings in the uniformity and conformity with the standard processes, which are the best standards across the globe we bring into the arbitration process. The Vishwanathan committee suggested the rules to be made part of the statute as a part of the one of the schedules itself, and give the power to the central government to amend those rules from time to time. Whereas the 2024 proposed amendment is proposing to introduce section 19(3), which will give power to the Arbitration Council of India when it comes into existence to make these rules, and the due regard will be given by the arbitral tribunal to adopt those rules. Now, there are a couple of concerns with this. One is these rules are not binding on the arbitral tribunal. They will only have a due regard to these rules, and these rules can be amended from time to time by the Arbitration Council of India. The other aspect is also party autonomy. Can the parties be forced to go have the rules adopted? This is very similar to IBA rules on taking evidence. This is soft law, whereas this will be neither part of the statute nor part of the soft law. So this will be something unique which will come through the legislation where the rule-making powers are given to the Arbitration Council of India. Nonetheless, this is a welcome step because it will at least bring in some kind of a guidance to the arbitral tribunals. When they adopt these model rules, they would be able to conduct the arbitration in the manner which is expected in any international arbitration setup. Even though it is in a domestic between two Indian parties, the rules should be common for both the set of arbitrations, international seated in India as well as between two Indian parties, domestic seated in India. So that is something we are trying to achieve. Now we'll have to see how the rules are framed, and the Arbitration Council of India will have to take the rules by way of a consultative process. The other aspect is the fees. What was happening is that Schedule 4, which was introduced by 2015 amendments, was criticized because of not adequate for all kinds of arbitration. Subsequently, the judgment by Honorable Supreme Court in FCON's case also brought about the issues with regard to Schedule 4. Mr. T.K. Vishwanathan committee suggested omitting Schedule 4 altogether and also omitting Section 11A, which allows the proposed Section 11A, which will allow the central government to amend Schedule A. What we have now in 2024 is also to allow the Arbitration Council of India to propose fees where the fees are not fixed by the institution or by the parties. So therefore, there is that vacuum with regard to the fees is to be filled by determination by the Arbitration Council of India. Again, this brings slight kind of uncertainty because for a particular arbitration, the arbitrator should be allowed to fix the fees if the parties agree for that, and the Arbitration Council of India can come up with the parameters for that which the arbitral tribunal may or may not accept. That is the best way for ad hoc arbitrations. For institutional arbitrations, of course, the institutions have their own schedule of fees. Many of the institutions have the cost calculators on their website. So if you know the amount in dispute, the entire fees of the arbitral tribunal as well as the institution can be known before even we start the arbitration. So that is something is very good to bring the certainty between the parties that what would be the cost of arbitration. With this new amendment of 2024, we have tried to ensure that there is a certainty, but this is not that transparent because we don't know what the Arbitration Council of India would find the fees to be an appropriate fees in a particular set of circumstances. So the best way is to follow the institutional arbitration or at least accredit those institutions. Their fees can be adopted by the arbitrators, if at all, even in ad hoc arbitration. So we bring in the best of institutional arbitration into the ad hoc arbitration by adopting the rules, model rules, which will be applicable to ad hoc arbitration, as well as the standard set of fees which the institutions have already determined can also be made applicable to the ad hoc arbitration. Now, it will all depend on the Arbitration Council of India as and when it is formulated to implement this suggestion, because this only enables the Arbitration Council of India to make rules and prescribe the fees. Now, the manner in which the rules are framed and the fees is prescribed will have to be taken into consideration by the Arbitration Council of India, and also can be through a consultative process where the Arbitration Council of India can invite views from the stakeholders and then come to the conclusion whether how to frame the rules and how to prescribe the fees. But in all, it's a very positive development, and both aspects of time and cost is being taken care of by way of 2024 amendments. Thank you.
Well, I think those those views are most useful. And I think there is a thin line between reducing the ad hocism in ad hoc and institutionalizing the process of ad hoc arbitration. One can only hope that the Arbitration Council of India, the rules that come out with regard to fee and the model code of conduct are, they have certain clarity and they really improve the quality of arbitrators. I think accreditation, whilst it's important to accredit arbitral institutions, I think accreditation of arbitrators is equally important as well, because I think where issues of ethics surface more to light and institutions like the government are opting out of arbitrations, I think these accreditations, genuine accreditation, will go a long way in resolving that issue. So, friends, from one very seasoned expert to another very seasoned expert, we have Ratan sir with us, who's been really a stalwart in this field for over 30 years now. Sir, I had, again, two and a half questions to ask you. I won't ask you three, as I've asked others, but Sir, the question that now comes is that, yes, there are no two views to the fact that institutional arbitration is the way forward. Yes, streamlining ad hoc arbitration is very, very laudable. But for institutional arbitration to be the mainstream option in India, it will have to percolate across the country. It cannot only be constricted to traditional commercial hubs like the NCR region, Bombay, Hyderabad, etc., where, of course, the shift is far more prominent. What challenges, sir, do you actually foresee in making that a reality? Do you think costs will play a factor? Because there is a school of thought that stakeholders feel that institutional arbitration, as I alluded to earlier, is too prescriptive and too costly. A lot of our MSME clients actually prefer ad hoc arbitrations. Could you just address some of these challenges that we currently face in India with regard to making institutional arbitration the norm rather than the exception?
Thank you, Arush. My Ladyship, Justice Kohli, Attorney General of India, Mr. Karya, Arush, dignitaries in the audience. Multiple questions as usual, Arush. And you very conclusively said that institutional arbitration is way forward. And this is a statement which is coming from all quarters, and this is the way forward. I also agree with that. But ad hoc arbitration is the purest form of arbitration. Culturally, we always have had ad hoc arbitration. Subsequently, with complexities of transactions and requirement of more and more neutral decision makers, and because of trans-border transactions, we had institutional arbitrations coming in. Issue today, so far as India is concerned, I strongly believe that arbitration is as good as the arbitrator, whether it is institutional arbitration or ad hoc arbitration. Even if tomorrow you have all arbitrations going to institutions, will that really make the changes which we are looking at? Answer is no. First thing first, and you hinted on that. Quality of awards and the decisions which we see today, and we have been seeing for quite some time, is really a worrying thing. A couple of years back, I was speaking in a conference in Kuala Lumpur. And I was saying that India is the place to go to and so forth. And lots of all law firm senior partners, the sitting judges, all were in audience. Mr. Sundara Raju, Datuk Sundara, who is very popular name in India also. Sundara got up and he said, Ratan, but you have to Tell us why it is that in India almost all arbitration award is challenged in courts. I gave my defense, whatever. I said that now we have a new regime in which you have to deposit the awarded sum in court only, then you can challenge and so on and so forth. But that is like shying away from the reality. Justice Kohli talked about minimalistic judicial intervention. Why it is that almost every award is challenged, and why it is that good number of awards are set aside? If you ask me, only reason is quality of awards. And this happens for two reasons. One reason is that appointment of arbitrators, either by the parties or by the courts in default appointment procedures under Section 11 and so on and so forth, very little attention is given to the expertise of the arbitrator for that particular arbitration which is before the court. We have fantastic pool of arbitrators, fantastic pool of retired judges, good number of lawyers. But question is, every dispute is not meant for every arbitrator. Historically, arbitrators used to be domain experts. And unless we do it, the quality of award will suffer. That is one. Second is, even big names in the Indian arbitration circuit, sometimes when you come across the awards written by very big names, you think twice about the award. And one of the reasons which again I very strongly feel is that the number of hours which were required to be given to writing of that award in that particular dispute was not available with the arbitrator. Professor Doug Jones, one of the finest arbitrators, particularly for construction industry, my very old friend, is my co-fellow in International Academy of Construction Lawyers. Recently, he was in India and Delhi, and we were having dinner together. He said, Ratan, I was sitting with one Mr. So-and-so other day, and I perchance asked him, how many arbitrations you are doing these days? You have running arbitrations. And that gentleman told me that he is currently doing 87 arbitrations. And Doug said, Ratan, I can't believe it. Why it is that? I'm not against arbitrators taking up matters which keeps them occupied and busy. Problem is, the culture we have in India for deciding arbitral disputes. Cross-examination go on for years together. It is not happening in one stretch. Final arguments, oral arguments which we call it here, otherwise internationally we call it trial, which clubs both the examination in opening statement, examination in chief, cross-examination, oral submissions, concluding submissions. Internationally, all of this happen in one go. If we create a culture in India where arbitrators start a case and ends with that case on a particular day in a fixed timeline, uninterrupted, their whole attention for that week or 10 days will be to that case, and quality of award is bound to improve. Otherwise, what happens is, in a cross-examination, another thing, again it is a cultural issue. and Attorney General talked about that, the culture. In India, culturally, arbitration is just replica of court proceeding. Problem here is, in court today, your case is presented before Judge A, but at the time of final, arguments, or at the time of writing of judgment, you will have Judge B or C or G. Now, how to deal with that? One particular thing which is otherwise very prevalent in arbitration, whenever I sit as arbitrator, very first day, when I sit for any procedural hearing, by the time whatever paper I have, I would like to go through them and understand what is the real dispute. If you as arbitrator understand the nature of the dispute before you hear for that particular arbitration, you will be in command of the whole arbitral proceeding. You will be able to understand and decide all these interim applications coming before you. You will be better placed to decide discovery application. I was doing one international arbitration seated in India. We had gone for foreign experts and so forth, a lot of discoveries. One particular chairman of a particular tribunal says, Mr. Singh, do you think we know what is the real issue, what is relevant at this stage of discovery? I'm sorry, this is not how it works. So therefore, my suggestion is, one, that you need to have arbitrators who are specialized, or if that is not the possibility, because till now we have not created specialized bars from where you pick up judges in high courts and the Supreme Court. We are more like generalists, all of us. In that case, second alternative is that let there be continuous hearing. What is the effect of it? Effect of it is no arbitrator will be able to take 100 cases into arbitration, 100 cases. Let one arbitration gets over, two arbitration gets over, you keep getting engagements. So quality really improves. Next, and we are talking about this guideline for the arbitrators. When you see the requirement of term of reference in institutional rules, what is this all about? At the time of writing term of reference, arbitrator is supposed to know what is the dispute between the parties and what is the position taken by the party. So, on the very first day, the least which arbitrators should do is, while issuing the first notice to the parties, let arbitrators write on the very first procedural hearing, let both sides talk about their cases in 20 minutes. Once you get to hear that, otherwise what is the culture today? Culture today is that arbitrators will open their file either at the time of final arguments or at the time of writing of the award. Once you understand the real dispute in the beginning or the first day, then with the kind of the legal brain we have in country, we can really do wonders. So these were my couple of suggestions. Thank you, Arush.
No, sir, actually, I think the applause also states that there are actually real-time challenges that we as an economy, as a country, which, as I said, harbors aspirations of becoming a hub for institutional arbitration. I think it has to also be a practitioners' movement, a stakeholders' movement. It cannot always be a statutory imposition or some draft amendments or some rules and regulations. I think you highlighted real issues like quality of awards, lack of expertise in our, in arbitrators. I think the choice of arbitrator has to be, today we are in an era of domain experts, horses for courses, as they say. We cannot have a particular arbitrator specializing in a particular practice area, being an arbitrator, arbitrating in over 80 arbitrations, which are completely alien to his or her practice area. So I think, yes, attention to detail is very important. It's very important for each arbitrator to understand his or her area of expertise, so that and work needs to be channeled and apportioned in that direction, in that manner. Sir, but you highlighted a lot of challenges and obstacles, but with the quality of speakers and the luminaries we have on stage right now, I can say this with some daring certainty that wherever there is a challenge, there is a way forward. So my last question is actually a common question to all. And I would actually start in reverse order because the chair should have the last word. Sir, my last question to everyone is, it's a common question, and this is one question. Assuming the draft amendments are incorporated as is, without any change whatsoever, do you think they will grease India's wheels in its journey of being an institutional arbitration hub? If not, then what are your suggestions? One suggestion each. Ratan sir, if we can start with you, then we can go in reverse order if that's fine.
You asked at least 3 questions from each panelist. So don't tell us one answer. I'll give you 3 answers. First of all, your question is, if draft remains as it is, I have one worry, and since the Attorney General is also sitting here, there is famous saying, if you throw peanuts, you get monkeys. It should not happen that while fixing the arbitrator's fees by the Arbitration Council, the kind of fee which are fixed should discourage good arbitrators from arbitrating. When you talk about good arbitrators, if you want to really make an institutional hub, you are using the expression, then you cannot exclude good international arbitrators, foreign arbitrators as well. And good size of disputes, complex disputes require experienced, seasoned, generally busy arbitrators. So therefore, that is one caution. So far as this guideline is concerned, I have one suggestion to make. There should be some talk about chase clock method, some hint about that, which is fixing of time, like in international arbitration, we commonly see this, where both sides say, I have 5 witnesses, other side says, I have 10 witnesses, I have to argue this, I have to argue this. Tribunal will say, okay, we give you 3 days time, 4 days time, same timeline, days, number of hours, rather it is number of hours, number of 72 hours to one side, 72 hours to other side. Now during those 72 hours, it is your business, it is your decision, how many witnesses you want to cross-examine, how many hours you want to argue, which witness you want to cross-examine, which particular issue you want to make submission on. So because Tejas also talked about that it should be time effective. How do you make it time effective? In one go, let us have a timeline fixed for parties. Another thing, very famous in all jurisdictions about Clatterbank thing, which is basically Clatterbank versus Clatterbank case, settlement thing. In order to encourage settlement, even there is a latest Australian judgment on this. During the course of proceeding, if a party gives a without prejudice offer to other party in a sealed cover, which sealed cover remains with the arbitral tribunal, tribunal will never open that till the time they are going to decide the case and award the cost. If there is an offer for 100 million to other side, today in the middle of proceeding, and that offer is not accepted, and tomorrow if that party gets less than $100 million, then in that case he has to suffer all the cost for the day, from the day when that offer was given. These things work really in a big way. So these were my quick 3 remarks. Thank you.
Mr. Karya.
Yes, so as far as the proposed amendments are concerned, all of them are good because it was pursuant to a exercise which was done by Mr. T.K. Vishwanathan committee. We all took feedback from all the stakeholders and then come up with the suggested changes. Some of them are very good. So one is the recognition of emergency arbitrators. That reduces the burden on the court drastically when we use the institutional arbitration and have the emergency arbitrator to decide interim measures, because that is something very positive step. We have been trying since 2015 to include emergency arbitrators definition into the definition of the arbitration tribunal, which would go a long way in recognizing that. The other aspect is the challenge of the award. Now, this particular round of amendment allows the court to partially set aside the award, but it does not allow to modify or change the award. So if you see the other jurisdictions like Singapore or UK, there is a power given to the court to change the award so that the another round of entire arbitration after setting aside of a part or the full of the award can be avoided. For example, the interest rates can be modified by the court under 34. Of course, the tribunal is given a lot of powers in the amended proposed amendments, but there are certain concerns like appellate tribunal. Now, who will sit as at the appellate tribunal, and whether we are adding one more layer to the whole delay process, because what would happen to the first award, whether it would be subsumed into the appellate award. That also will have to be seen, who will appoint the appellate tribunal. So there are certain concerns with regard to those amendments, but overall, we need to see that how many times we will keep amending our law. And as Arush said, it's a mindset change which we need to do. Actually speaking, there is no need to amend the act if we amend the way we do our arbitrations. The easiest way is to decide the final hearing date on the first day of arbitration, as Mr. Singh said. You work backwards on that, have the procedural timetable PO1, the PO procedural order number 1, which is the entire timeline of the arbitration should be there and strictly should be enforced. And have the experts appointed as the arbitrators, again have the rules which are the time tested and the best rules, internationally recognized rules. There is nothing that we need to do which is not available, otherwise that we need to go back to the act and keep amending it. Because more we amend, it will give another round of interpretation to the courts. The courts will interpret those issues, then it will be a complex issue which one will be interpreted in which way. Then again we will go to 5-judge, then 7-judge, then 9-judge bench in Supreme Court to clarify small issues. We need to change the way we look at the arbitrations. We have to simplify it, streamline it, and do it in a more simple way. But of course, if we think that there is a need to have the arbitration regulated by Arbitration Council of India, which itself is a slightly concerning thing, because the earlier proposal was to have an Arbitration Promotion Council of India. The word promotion was removed from it, and now it's only an Arbitration Council of India. No other jurisdiction we have a regulatory body which regulates the arbitration. It's the parties who decide. It's an alternative or maybe a parallel to the judicial process, because some of the cases which go to arbitrations cannot ever go to the court because of the simple volume and the complexities involved in those cases. Plus the confidentiality. Nobody wants to go to court and wait for years and discuss their confidential information in the court. So the best way is to simplify the arbitration process. Do it in the way it should be done, and to be done by the experts who knows how it is to be done. And then we may or may not need the amendments as we are proposing. Thank you.
Now to our honorable co-chair, Mr. Venkatram.
Mr. Kari was talking about little skeptical about how many amendments we can have. I'm not skeptical about that. I think there are a couple of misgivings we have in mind. When people compare London, Singapore centers of arbitration, they are merely centers of arbitration. They are not nations like India, which in every economic policy decision we take, will have to be a certain amount of assessment and evaluation. So if an arbitral award or an arbitral process is going to have a certain economic impact on how you go about your economic policies, I think we stand alone. Now, recently, I had 2 arbitrations, particularly, for instance, take a gas and petroleum arbitrations. They are not merely a question of procedure, they're not merely a question of witnesses, it's a question of what something goes wrong in the entire procedure and the award, then you're looking at what happens to the entire industry. Therefore, I think if the amendments will probably deal with some of them, and we learn very soon that the amendments have not focused in the right direction, of course, I think Parliament will take a call on that. I don't think, after all, our Constitution has undergone more than 135 amendments, right? And somebody say US Constitution only 25 amendments, but they have too many problems there, right? Therefore, amendment is not an issue. And this where I think, again, as far as a certain area of flexibility is concerned, lawyers and the arbitrators can play their flexibility. There you don't need an external nudge, but a certain outer regulation, external regulations are concerned, they will have to be, I think, more firm. So the interplay between the firm regulation from outside and what an arbitral lawyer and an arbitrator can do in what fashioning your processes in every occasion you meet, I think there will be a good match between that. Today, because there is no good there is a mismatch. Therefore, you have all the skepticism. I think as the arbitration bar goes, it will be in a position to say innovate and also create within its broader regulatory framework how you articulate your procedures as suitable to a particular arbitration. So I think that flexibility, if it is given in the hands of the arbitral process, India would have shined better. So I don't think we need to be too skeptical about all this. And finally, I said, as we're looking at the cost issue, either ad hoc or institutional, we will still face that for a period of time, and still we reach the plateau, right? I think we are yet to reach that. And recently, I came across an arbitration which happened way back in 2011. The tribunal did not rule on costs. Then question arose, and how will they do it? Became functus officio. Matters went to Malaysian court, English court, and then landed on my table to find out what can be done now. So it was a difficult question for me to answer. So, but then I asked only one question: who all was responsible for this? So some element of responsibility will come around to the question of ethics. So ethics is not merely what the arbitrators fail to do, but every one of us who can add to the quality of the arbitral process. I'm looking at ethics from the larger meaning, not mere a moral issue. So I'm looking at it very differently. Therefore, I thought the arbitration bar would be in a position to probably bring in a lot of fresh insights and vigor. So we're looking at insights and vigor.
And now for the crowning moment and the final word.
I think we've all of us here I've heard my panelists, starting from Tejas and Ratan and learned Attorney General. The focus is, no doubt, there are amendments proposed and there have been frequent amendments to the enactment. We're also aware of the fact that by the end of the day, every amendment for one reason or the other is challenged in the court of law and travels right from the High Court to the Supreme Court, and the benches ranging from 3 to 5 to 7, as they just said. It's a fact. It's been happening. And I wouldn't be surprised that some of the amendments here, particularly the 2-tier one regarding the arbitration tribunal itself, would be open to challenge, though we know that there have been judgments by the Supreme Court, 3 judges bench on, which had decided that Centro, right?
Yes.
Which had decided that it is very valid, it is permissible. If the parties think that it is their autonomy, they want a 2-tier, there should be nobody to stop them, and it should be proceeded with further. So there could be a seat in India, which could be the first tier, and a seat in London, which could be the 2nd tier. and all of that. So we know that there was Centro 1 in 15 or 16 and Centro 2 in 2020, which went on to hold that if it was the appellate tier, then the appellate tier's award was treated as a foreign award only to be meant to be implemented here and nowhere else. So there are nuances attached to it. But I would say for us to go the institutional way, we need not only to focus on the ethics or the procedures or adopted by the institution. The ethics of the arbitrator should be squeaky clean. When we talk of international arbitrations, particularly so, that they're as neutral as they can be, with no tinge or no stigma attached to them. Similarly, for those who are in the arbitration field or practice, it is imperative that lawyers do not treat arbitration as a second fiddle, which is happening without exception in our part of the world. In nowhere else would any lawyer request a tribunal to fix a hearing at 4:30 p.m. The focus should be that if there is an arbitration that has to run, as Ratan just said, and it has to be time-bound, whether it is 72 hours or 160 hours, it should start in the morning as any matter would and go on and end at the end of the day, so that that continuation is maintained. If there is a continuum, then the timelines will also reduce and everything will fall in place. But if we start at 4:30, after a lawyer has had a full day at work, he or she would be fairly exhausted, would like to wind up at maximum by 6:37. What would one achieve by the time you warm up in that arbitration? So again, it's a question of your approach and the mindset. That is equally important for promoting the cause of arbitration. Institutions, coming to institutions and institutionalization of arbitration, we haven't forgotten our cultures. We talk of traders' guilds for donkey's years. For centuries, India takes pride in traders' guilds. Those are also specialized arbitrators, aren't they? In a manner of speaking, whether it is the cotton trade, whether it is the spice trade, whatever it is, there were traders who would select their own arbitrators within their own field, who were specialists, who knew the nuances of that trade and would be the right persons to decide that dispute based on it. Today, we don't have spices or we don't have cotton, but we have oil and we have solar energy and we have windmills. We have all of that gamut, which also is a specialist field. So as it has been stated by members, my co-panelists, specialization helps. And we should also remember, when we go the arbitration way, and when I say we, I include myself as having worn the mantle of an arbitrator, that one should be open to training, to learning, not just to proceed in an arbitration as if one was wearing the mantle of a judge. Sometimes you have to step back and learn. And that ongoing process of learning, whether as a lawyer or as a jurist or as an arbitrator or mediator, should never end. So that one goes back richer. And that is what I started with, that we hope we all go back richer with our interaction today. We go back richer in each arbitration proceeding and learn, and not at the cost of the parties, but having done some homework in advance of where we are heading and how would we take the matter further. That is imperative. That transcends all these amendments and drafts that we are talking of. We are talking of the foundations here, the very foundations on which this process and this whole building is to be built on block by block. When we go to the international platforms, which we all have been going, and tom-tom ourselves as one of the best venues for arbitration, well, then the proof of the pudding is always in the eating. We should be able to demonstrate that we are ready in any which way to compete with the best of the international institutions, with the best of the arbitrators, be a neutral field, and of course the best of the bar, of which Mr. Venkatramani thought about making, Mr. Venkatraman thought about making, and that is becoming a reality. Everything takes time. The seed is sown. It does, but we need to expedite. Otherwise, truly, on the international platform, we may miss the bus. It is imperative that we pull up our socks and get down to doing it. That is the bottom line, I would say. Thank you.
I think our learned co-chair wanted to say a final comment. Sir, by all means.
Everybody was talking to me about DMRC. So wherever I go, I tell you, what about DMRC? I think I only two comments on it. Like Antule's case, right? It cannot be used in all possible contexts. It is practically it's a standalone case unless you are able to creatively use it. I think DMRC is like Antule's case, like a pole star hanging somewhere in the sky, which will tell us what will happen when something goes seriously wrong. But that's my story around in DMRC. So I was very reluctant to push it beyond a point, but when we understood where the story was, then we had to do that.
I think we now open the floor to the audience in case there are some questions. I think we can take 2 questions because I'm told the tea is still hot and the snacks are still good. So 2 questions in case. I think I can see one hand over there. Ma'am, did somebody file the mic? Yeah, great.
Check. Good evening, everyone. My name is Shani, and I'm a third year law student. Sir, you specifically talked about the amendment of emergency arbitrator as a form of an interim measure. So, as someone who worked on comments for the draft amendment bill, that's one particular section I worked on. So, I was against, personally against, that being implemented. So, can we talk about how that may or may not affect party autonomy in case that's implemented? That's my question to you, sir.
I think this question is to Mr. Kari.
So your question is about emergency arbitrators amendment not being implemented.
So you talked about how that's one amendment you commend a lot, but I hold a contrary stance. So that's why I thought I should ask.
Okay. No, so ultimately the power to go to court under Section 9 is always available. Emergency arbitration is an option given to the parties who would like to go for an appointment of an emergency arbitrator, because there are clear advantages of emergency arbitrator is that you don't have to go to the court. The emergency arbitrator gets appointed within 2 days. Within 14 days, the emergency arbitrator comes up with a decision. That decision can be either amended, modified, or vacated by the regular tribunal as and when it is constituted. Now, what was happening is that unless and until we recognize that set of orders passed by the emergency arbitrators as if they are orders passed by the tribunal, although we had the case of Amazon versus Future, which Supreme Court has recognized that concept, but we needed to have the corresponding amendment to recognize that in the Act itself. And that is why we are now proposing to introduce Section 9A, which will recognize the orders passed by the emergency arbitrators as if they are the orders passed by the regular tribunal. Because the emergency arbitrator word or the concept was not there in our Act, which if we compare that with the other jurisdictions, they have already introduced that. We have arbitral institutions which provide for emergency arbitrators in India, but Act didn't provide for it. Therefore, we need to bring in that amendment by introducing Section 9A. Which will bring in, of course, we have the judge-made law there, but if the statute recognizes, it will go a long way, and it will also promote the use of emergency arbitrators, which is reducing the burden on the court. Because Section 9 court, it either goes to the district court or in the International Commercial Arbitration of the High Court having original jurisdiction, it will go to the High Court. But we needed to bring that kind of uniformity with regard to the rules of arbitral institution in the Act. And that's why I thought that it is a very welcome step.
Yes. You take a contrary position on emergency arbitration, but I'm sure your position for arbitration would be that it is an appropriate dispute resolution mechanism. So you are convinced with arbitration as a very good mechanism. If you are, then you should be agreeing with the provision for emergency arbitration, because all the benefits attached to arbitration is attached to emergency arbitration. In last 1.5 months, I sat as emergency arbitrator in 2 matters, foreign parties, and in one of those days I sat till 10 p.m. and it was my the dispute was of my area of expertise, or whatever you call it, construction. I wrote 90 pages, one in 90 pages award and another in probably about 87 pages award, till 10, and both sides, and the timeline, you know the timeline. In that timeline, both sides' lawyer went completely satisfied that they were given fullest hearing opportunities. So the benefit which are attached to arbitration, that both sides get sufficient opportunity, they are heard by people who know the subject, who are ready with the file, who are ready to give the time. Because you don't get all of this in courts. So therefore, if you are happy with arbitration, be happy with emergency arbitration.
I think there is one more. Can we take up one more? So, can somebody just pass the microphone to gentlemen?
My name is Kumar. I'm a civil engineer and arbitrator. My question is to Mr. Venkatramani is about the new bill which is under consideration, and it is about the topic of fast track arbitration. It is there present in the existing bill, and it is there in the new bill as well. But this procedure is hardly used. Now, what is happening is, can we think of introducing a threshold limit, say up to so many million or so dollars or so many crore of rupees? If a dispute arises, it will normally go for fast track mechanism only. I found out, I searched all the rules of Indian arbitration institutions. That threshold is not there, but I could find in ICC. It calls for a $3 million, if my figure is correct, as a threshold limit. Now, advantages are many to the entire arbitration space in India. It calls for only sole arbiter to be appointed. That means pressure on arbitrators' time is reduced. So if you want to have continuous hearing for 3 days, 4 days, or whatever it is, it's not that you have to ask for 3 arbitrators again and again. The point Mr. Ratan Singh said that people have 87 arbitrations and things of that kind. If you have only one arbitrator or up to a particular threshold limit in common contracts or in PSU contracts or in other contracts, it will help a lot to the entire industry. See, what is the purpose of arbitration? The purpose is that can we do that in the new way?
In fact, this matter is receiving my attention.
I politely communicated that we will have to wrap up this panel now, and in case there are any questions, we can, I'm sure in case our esteemed speakers are staying on, you can of course ask them and reach out. But today just want to conclude by saying that we are in an age and era of conferencing. These kind of events happen very, very often, but it is extremely rare to find such a high profile panel exchange such informative, engaging, captivating thoughts. So a huge round of applause for all our esteemed speakers. It's been an absolute, it's been an intellectual feast, really. So I think Sumedha, you have some announcements to make. Yeah, over to you. Thank you.
Thank you, Arisa. I'd like to thank our esteemed panelists for such an engaging and enlightening session. I'm sure the positive exchange of thoughts will help us take concrete steps to make India Hub of International Arbitration. Thank you, leadership, for sparing your precious time and joining us today. I'd like to thank A.G. Venkatramani sir, Ratan Singh sir, Tejas Karya sir, and Ash Khanna sir for joining us for the panel and discussion and being a part of the conclave and your continued support. We have a reflections board for sharing your thoughts and the feedback, so I'd request everybody, and especially the panel, please share your thoughts on the board outside. Thank you, everyone. And I would like to request panelists and audience to join us for the high tea break before we resume quickly for another engaging session on arbitration in banking and finance disputes, the way forward, and the keynote address by our chief guest, Shri Harsh Malhotra sir. May I please request for a group pitch on the stage, please?
Yeah, welcome. Thank you.